17th April order.
Yes. We are inclined to accept the prayer made in the present application.
Just yes, 17th April. Yes.
We are inclined to accept the prayer made in the present application insofar as it relates to assistant teacher of classes 9, 10, so and so, not found to be tainted, subject to the following conditions. An advertisement for fresh recruitment to the aforesaid posts, no addition, shall be published before 31st of May 2025. Then the examination and entire recruitment process shall be completed by 31st December. These are the two things, Lord. Supreme Court says do it to those posts by 31st May and complete by 31st December. Until then, the non-tainted will continue and get this.
I will permit you to read the rest of the orders. Now the problem is this: today, if court interferes with this selection process by making an observation or by setting aside this notification dated 30th May 2025, would it not lead to relaxation of time schedule fixed by this Supreme Court?
With deepest of respect, the court order is not to be observed only to maintain the time schedule. The court order has to be observed, and it is the duty of this court.
It is absolutely correct. It is under true letter and spirit. Now, but when with a default clause in 17th of April, this order was passed, then where is the scope left open to this court?
Yes.
To today, suppose hearing both sides, I set aside this notification dated 30th May 2025. Now that lead to relaxation of the time schedule or extension of time schedule by this court, that is according to this court is not open in view of the tenor of this court order dated 17th of April 2025.
But if your lordship finds that the first paragraph says advertisement for those posts is violated, will that be permitted? When the honorable court lord is really thinking in terms that I have to...
That is troubling this court.
No, the court has to set aside. The Supreme Court judgments are there. Article 144 comes into operation. This will be duty of the High Court to ensure that the Supreme Court order is followed. Here, in the name of following the Supreme Court order and to avoid the wrath of the court, they have issued a notification. And if that notification seems to be apparently illegal, would the court feel shy of not interfering? We want, let the time schedule as such be maintained, but you correct your notification. This can even be done by corrigendum. We want that this Supreme Court order should be complied with.
Come to paragraph 3.
Yes. The state government, the applicant, West Bengal Board Education and the West Bengal Central Submission shall file their respective affidavits by 31st May, enclosing that with a copy of the advertisement for fresh recruitment, as well as the schedule therefore, so as to ensure completion of the recruitment process by 31st December. In case the advertisement is not published by 31st May and the affidavits are not filed, appropriate orders will be passed by this court, including imposition of cost. Now, to avoid this imposition, they have published a notification that 31st May. But is that the notification?
Now, what is the effect of the order passed by the Honorable Supreme Court dated 17th April 2025? That do this by this time, file an affidavit. So therefore, Supreme Court is still insisting of the matter.
So it's not insisting the matter. The Supreme Court disposed of the matter. Kindly it comes to us.
Then what was the purpose of calling for an affidavit disclosing initiation of the selection process by issuing this recruitment notification dated 30th May?
To ensure that this is done. Otherwise, the application couldn't have been disposed of. Kindly see the last thing. The application stands disposed of in the aforesaid terms. Court did not keep any control over the proceedings anymore. If it is to be done by independent application. Now today, I was thinking aloud that if the honorable court
Mr. Bhattacharya, even after disposal of the appeal by order dated by judgment dated 3rd April 2025, this miscellaneous application was entertained.
Was by the state.
Yes. So then where is the bar in approaching the Supreme Court for getting appropriate clarification?
We cannot approach.
But at the same time, the hand of this court is tied in view of the time schedule framed by the Supreme Court with a default clause, Mr.
My lord, kindly forget that the court is only bound to maintain the time schedule. Kindly think court here sitting in the constitutional jurisdiction is my lord, also would be kind enough to consider
That a rule of law must be
whether
must
the
prevail.
Supreme Court
Yes.
other directions, Supreme Court others directions in merit is not followed or not. Date is not only something which is directive. If the
But tell me whether this date extension of time can be
I am not
can be
asking-
relaxed.
I am not
Because
asking,
today we are in the mid of July.
even then.
Now, if I set aside this notification dated 30th May
So I
2025,
don't say, need not be set aside.
then it will lead to extension of time for issuance of notification. Then today the resultant effect would be court has to give a direction upon the recruiting authorities and the state to frame a notification within fortnight or within 1 month. That will not lead to extension of time fixed by the Supreme
that
Court.
then the obligation would be upon the state and other parties that since this is the order due to, can you extend the time? But fundamental task would be,
So when you are approaching before this court, you approach the Supreme Court for extension of time.
why should you? I have to not first get a view that this is illegal. Supreme Court doesn't have the original jurisdiction to entertain a new notification. My lord is well aware that I cannot state a go Article 32 petition filing a challenge notification. It would not be governed. Therefore, I have to approach the jurisdictional court, and if the jurisdictional court finds that this is illegal, then consequently I can approach the Supreme Court saying, now kindly, my lord, now since this is the order that here also on 13th of April, 17th of April, Supreme Court categorically states, you follow recruitment process to that post.
Advertisement for fresh recruitment to be.
Therefore, if those posts,
Where which paragraph? Clarify that all orders will.
now will kindly come to me, lord. Advertisement for fresh recruitment to the aforesaid posts. Aforesaid post means, my lord, the 2016 selection. Therefore, if it is confined to 2016 procedure and law, there's no difficulty. Even today, they can issue a notification that this was a mistake. We will follow only 2016 rules and the vacancies.
And if aforesaid posts are clubbed along with the subsequent vacancies, where is the bar in the order?
Because under the rules, recruitment rules, you have to,
And how this can be restricted to the candidates of 2016?
because they,
Because that will in contravention of Article 16.
not at all.
It's a public
Public post,
employment.
well, the public employment for the vacancies declared. This is not a new process. This arises because of intervention of the court. Had the court not declared the selection was over, then these vacancies wouldn't have come. Can you consider this?
But nowhere division bench and Supreme Court has said, Mr. Nowhere, that this selection process has to be conducted in terms of 2016 SLST rules of 2016, and it would be confined to the vacancies.
That I will then again.
Nowhere it has been
I will
observed.
again invite your lordship to read the judgment in its entirety. But what was the issue before the court? Can you excuse me without deputation? That 2000 selection is bad.
Yes.
Now court finds 2000 selection is bad. Now court says do it afresh to those posts. Therefore, the rights of the parties which were there accrued at 2016 would be considered. The subsequent rights would never be considered because these vacancies were there in 2016. Categorically, High Court and Division Bench and Supreme Court says to those posts. Therefore, if it is confined to those posts, it will be confined to the persons who were then eligible. Otherwise, if 2016 election was not set aside, the subsequent vacancies, subsequent rules wouldn't have come into operation to tag with this. Couldn't have been. Therefore, reasonable and logical conclusion is that you have to hold afresh for 2016. Do it. We do not say that you cannot hold the examination.
So therefore, your sum and substance of your submission, Mr. Bhattacharya, is this first. These vacancies of 2016, 9, 10, 11, 12 are to be treated separately. And for filling up those posts, this separate selection process is to be conducted following 2016 rules.
That's the judgment, number one. And number two, kindly will again come back to the impugn notification. The notification is still inherently bad. And the Supreme Court, my lord, makes it very categorical that the tainted candidates would be barred.
Yes.
Prohibition.
That's true.
and you have allowed everybody to participate. Number one. Now, kindly come to the notice is inherently bad. Now, the kindly,
Now, notification, I would ask Mr. Bandyopadhyay two things. First of all, where is the prohibition prohibiting the tainted candidates to participate? There is no such prohibition. And another thing I would ask Mr. Bandyopadhyay to clarify that if you come to the mark provision
yes,
relating to allotment of
that
marks,
I was going to show.
now they are
Inherently bad. You are
that is also এই আমার এই ইয়েটা কোথায় ওই লাস্ট ইয়েটা দাও তো ওখানে নোট করা আছে
Oh, you have come ready. That's good. The marks.
First of all, there is no express prohibition prohibiting the tainted candidates to participate. That you will, I know you will take this point. And the second is
distribution of marks.
Distribution
How
of
could
marks.
the additional marks for teachers comes? Thereby, you want to give benefit to those who have been declared null and void by the Supreme Court. Distribution of marks. But that will also get blocked in the rules. That will also get blocked in the rules.
Yes, that is in the rule. It is there. Yes.
Schedule 2. At page 1110.
This prior teaching experience,
Yes.
whether 10 marks can be allotted,
Yes.
who has lost their job with a finding that there is egregious fraud. So how this can be reconciled?
And then again, if it is about the open recruitment for fresh recruitment.
10 marks for experience. Now, if a teacher who has rendered job in connection with 2016 SLST 9, 10, 11 and 12, how they will get
That
the
is-
marks?
You have correctly marked this. And then again, the distribution of marks was also changed
That I have seen.
to create another door for corruption. I use this expression with all restraint. Now you have seen these rules. Kindly come to this notification which is under challenge is of dated 30th May. And
Is there in the notification any provision that the tainted candidate?
If it is absolutely perfect, this is one. Other is there are some irreversible situations. Like in the notifications, the last date of form fill up is 14th. There are number of situations where because of the last date being 14th, many of them they are disqualified. They were qualified under 16. Some posts where they are now found to be not there, so they will not even able to participate. All I shall be praying today and an interim order without affecting any of the honorable Supreme Courts. Now there is a vacation. Supreme Court, honorable Supreme Court will be reopening on 14th. I would be only seeking, because I don't want your lordships to enter into the entirety of the matter, because it will cause lot of time, lot of intricacy of laws, and I cannot make a very biased interpretation. Both sides have their things to say. But till that time, kindly extend the form fill up. Supreme Court has got said nothing on that. Kindly come to the MA order. Paragraph 3.
17th April?
Yes, 17th April. Because if 17th April stops your lordships and lordships cannot.
Just two. Yes.
Kindly see paragraph 3. before that too, the examination and the entire recruitment process shall be completed by 31st December 25. This cannot be tweaked by your lordships. It is watertight. Cannot be. 3. State government, the appellant, West Bengal Board of Secondary Education and the West Bengal Central School Service Commission shall file their respective affidavits by 31st May 25. Cannot be tweaked. Enclosing therewith a copy of the advertisement for the fresh recruitment. Cannot be tweaked. As well as the schedule, therefore, so as to, kindly mark this, ensure completion of the recruitment process. This also cannot be tweaked. Now, 4. In case the advertisement is not published by 31st May 25, cannot be tweaked. And the affidavits, kindly look at it. And the affidavits, so it's a document itself, not about
Are not filed by that date, the appropriate order will be
exactly.
passed.
So therefore, lordships cannot.
For according to you, 31st of May cannot be relaxed.
Yes.
31st December cannot be
Cannot be.
relaxed. But a date can be relaxed.
All I'm
But there's a
praying,
problem.
I'm saying, all I'm praying that there are multiple problems which are fundamental in character. All I'm praying, kindly extend the date of form fill up by 1 month.
If I extend the date of form fill up from 14th July
Yes.
to 14th of August,
Yes.
in that event,
Yes.
it's a huge process,
No.
Mr.
Kindly
Dhar.
see the
That
irreversible
from
effect.
14th of August to 31st of May, 31st of December 2025,
Yes.
it may not be possible for the commission to complete the
Right.
recruitment process.
But there comes the clause and the super clause. I say that Lordship is seeing these directions of the Honorable Supreme Court as super
So court
clause.
needs to proceed taking into mind that the Supreme Court has fixed from 15th of July to 31st of December 2025 being the date
Yes.
by which School Service Commission has to complete the selection process.
Correct.
If that court accepts,
Yes.
then it is not open to this court to extend the time for filling up for submitting the forms.
The Lordship has ample power. The reason is this. This is one part of the Honorable Supreme Court order. There are other parts of the Honorable Supreme Court order which entitles me to participate. Now, large number of participants.
Any other submission, Mr. Dhar?
Malad, the irreversible effect is this. Kindly have a look at the irreversible effect. That my supplementary 1 page, page 17. This post is not even there. I've given the list.
Yes.
45% earlier it was the eligibility. Now it has become 50%. I won't be able to. So all I'm trying to say, there are other part of the Honorable Supreme Court judgment that has to be adhered to. There are this part of the MA order that is also to be adhered to. This now, while adhering to the time, can the other contents of the Honorable Supreme Courts by which I was entitled to participate, can that be taken away? I said, Lordship, do not answer finally. But kindly look at the liberal view and the narrow view. The liberal view would be if Lordship extends that, nobody dies in the meantime, when the matter is decided. Because otherwise, 14th is last date. None of them would be able to participate. So no matter what.
Any other?
This is, and as far as the contempt jurisdiction, my lord, that is a completely different purpose. Because there is a judgment of Parihar, paragraph 6.
But I have given reference 3 judgments. I have referred to in my note for the well-known proposition that legislator cannot make inroad into judicial power without taking away the basis of the order. For that, I will not referencing
This
3
is the
judgments.
paragraph,
Giving the reference to my last.
paragraph 6.
Yeah, 1970 Supreme Court 1292, then 1974 Supreme Court 1232, and 1995 6 SCC page.
What is the
60.
proposition? What is the proposition?
In a note I have mentioned paragraph 5 below. So it's unfair on my part not to apply.
Can you tell me the proposition?
Yes. Paragraph 5 I have noted. AIR 1970.
No, what is the proposition of law based on which you are citing this judgment?
On the question that this any order or subordinate legislation which is in violation of order of court is ultra virus constitution because taking inroad into judicial power without removing the basis of the judgment. Paragraph 5 also find that. And not I'm giving my hand. And yeah. ठीक है, you know. I hand paragraph 5. Last paragraph. Last page.
Yes.
And I have handed back my notes of submission to my learned friend, Mr. Bandyopadhyay, for his concern. So everything I'm putting on the table.
This is the judgment 96.
No hide and seek.
This is the judgment of J.S. Parihar.
Yes.
96,
And the copy of
660,
judgment that I handed
291.
to my laptop.
Clearly saying, if I can read two sentences, the question is whether seniority list is open to review in the contempt proceedings to find out whether it is in conformity with the directions issued by the earlier benches. It is seen that once there is an order passed by the government on the basis of the directions issued by the court, there arises a fresh cause of actions to seek redressal in an appropriate forum. The preparation of the paragraph 6 placitum, my lord, around G.
Yes.
And I say that,
Yes, Mr. Bond.
I say that there is a requirement of the new
Anything you want to add?
Kindly just
complete
let them
this
add it,
sentence.
after my just kindly.
Just
But
one
I
sentence,
thought
sir,
it
may I
that
just
one
complete?
item against I will argue. One item I will, then the one first Mr. Vikas Bhattacharya, I have to argue. Then two, somebody will take point. I have to argue.
You have to finish with one sentence. There is a requirement of the new rule because the SSC is required to change the waymark, which is the cause. Now they have made it preservation rules. There are several rules which were the reasons for quote and unquote corruptions.
Very
So
good.
therefore, I do think there is a need of a change. No doubt about
All
it.
these lawyers have appeared on behalf for the corrupted peoples before the on another bench.
I think allow
Now
me to say,
this-
Mr.
Ah.
Your turn will come.
Ah.
So therefore, I say there is a need.
You are arguing in my
Yes,
turn.
he will complete, Mr. Bandyopadhyay. Please take your seat.
You are arguing in
That
my
there is a
turn.
need because otherwise old rule which was found to be incorrect destroy the OMR that had to be changed. I also feel number of increasing vacancy administrative matter, nothing wrong about that.
Yes. That
Nothing
is
wrong.
also the view of this
There's
court.
nothing wrong about that. And I feel that
But those vacancies must be clubbed.
those vacancies can be clubbed, there is no difficulty. But all persons who are eligible to participate in 16, they should not be barred.
Excepting
Yes.
tainted.
Excepting tainted. Now, tainted, my lord, I read and found possible two views. Two views are possible. Though I am going to say tainted should not be allowed. That's my view. I will try to support that. But that would require a lot of time ultimately to come to a conclusions. So might be Honorable Supreme Court. But till that time, my honestly request before Lordships kindly ensure that no irreversible effect happens. So if the form fill up, which has not been touched by the Honorable Supreme Court, if that time by 1 month is extended,
That you have submitted, Mr. Yes.
Maroda, kindly. Otherwise, I will not be able to. Kindly, some kindness to kindly show to me, my lord. Some kindness kindly show to me, my lord. Item,
I will hear you.
Lord,
Mr.
I have
Bandyopadhyay.
other matter. I thought it item one. Your lordships will give me the answer.
Give importance to this matter.
No,
Mr.
that-
Bandyopadhyay.
that's all right.
You know the
I am not.
outcome of this matter.
I am
You know
not.
very well.
I
So therefore, the lawyer.
I am not
civil
saying
lawyer
so.
should give some importance to this
Absolutely
matter.
correct. But so far item one, when it is happened, then item one, I will
Let your
give the
junior
answer.
argue in that matter. I will hear you in this matter. Yes. Please take your seat.
Very nice.
Accepting Mr. Bhattacharya's submission from paragraph 7 onwards.
11 matters have come together.
There was a time fixed by the Honorable
I would
Supreme
have
Court.
said this.
Here, for the in the judgment of your lordship. This is your lordship's judgment. Paragraph 7 onwards. Your Honorable Supreme Court fixed the time limit. No, that's not this another matter. In parallel. Within
That primary matter.
exactly.
In IOS.
Now your lawsuit say that they should be allowed if situation arises, parties will be at liberty to approach the Honorable Supreme Court for extension of time.
Yes.
So extension of time is not a matter. The second submissions I tell your lawsuit. So for the main judgment your lawsuit that substantially defines and concludes the right of the parties. And the last order, you must only the procedural.
But in
part.
that judgment, I have not extended the
Now
time.
I tell you lawsuit. What happens? Because of new rules.
That is a situation where court has held that NIOS will delete a similarly circumstanced candidate, but they are not the appellants before the Honorable Supreme Court. So therefore, they are to be considered separately by submitting their credentials, their eligibility to be
But that,
considered.
the time limit was that only the appellant to be appointed by 31st.
That was in connection with the appellants only.
That's your lawsuit. That's why I could not complete with that. Here the situation arises because your lawsuit-
So far 2016, 19, 11, 12, there is no division. Only the all the candidates case are before this court. Now Supreme Court has specifically said that by 31st May you have to initiate
complete the
proceedings,
appointments of appellants.
and by 31st of December you have to complete the process, 31st of December 2025. Now if this is the specific direction of the Supreme Court with a default clause directing the authorities to file an affidavit disclosing the recruitment notification, failing which an appropriate order should
They have issued the recruitment
These
notification.
are a different ramifications, Mr. Shannan.
According to me, it's not that. If there is any default clause of the Supreme Court order, if ultimately found by your lawsuits that this is a violative of the rules and the Supreme Court order, they have to go before the Supreme Court and say because of this you extend the time. This is the court of the order of the Constitutional Court.
So
That was the same
that
situation.
you
in the
also
earlier.
approach the Supreme Court praying
But
for
they will
extension of time.
approach your lordships in our matter directed. The board will approach
Yes,
for extension of time if the consideration cannot be made.
very well.
Second, your lordships, both the petitioners in item number 8.
Yes.
Now, both the petitioners are in earlier round of selection process were selected. They were serving. One in English, one in political science. Now, because of the new advertisement, they are not entitled to be appointed.
45%, 50%.
This is the one point. Now, your lordships kindly consider this judgment of our High Court. This is reported. Neel Madhav Das and others versus State of West Bengal and others. Your losses might remember this situation where two selection process was clubbed together, 2005 and 6, by an advertisement in 2009.
Yes.
This High Court interfered with the situation. Your losses kindly consider page 2005, page 5. Kindly see these are the points. Controversy, number of vacancies different, year of vacancies different, category of vacancies different, date for calculation of qualifying age are different. Now your losses will find next your losses page 11. Why the single bench orders were affirmed that two vacancies cannot be clubbed together. Page 11, the second paragraph and third paragraph. Third paragraph, fourth paragraph. The qualifying age in respect of recruitment.
Third paragraph and fourth paragraph.
Yes, without number.
Yes.
The qualifying age in respect of recruitment process initiated pursuant to the requisition dated 2005 was different from subsequent recruitment process 2006. And then in the aforesaid section, the candidates in respect of 2005 recruitment are separate in every respect from the candidates sponsored by the subsequent requisition. The advertisement means they will re-advertise the vacancies already declared. They cannot include the subsequent vacancies. They are governed by the subsequent rules entirely. These are my answers.
That is the submission of Mr. Bhattacharya.
Exactly, your Lord.
So the separate posts are to be considered.
অনেক সময় একটু অনেক করেছে একটু বস এটা আমাকে একটু শুনতে আরে 2 মিনিট একটু
Yes, Mr. Bandyopadhyay.
হ্যাঁ
Yes, you start.
মানে কাইন্ডলি সি I just tell you lot ভাই এবারে নাও মাই টার্ন মানে কাইন্ডলি সি you will give the answer you will
I will hear you later. Yes.
মানে kindly just I take your lordship from the very basic thing. Let us tell your lordship the facts. There was a selection in 2016. In selection, there is a panel.
You are representing whom?
I'm a SSC. Panel is prepared. Who are unsuccessful? Those whose names are not in the panel. Correct? In the panel, those names were their panel. High Court directed to make a CBI inquiry. Right? From there, tainted, untainted categorization have come. These disqualified persons, in their cases, it has not been done.
Yes, this.
These disqualified persons, whether tainted or whether untainted, nobody knows. What has happened? Ultimately, entire selection process is gone. Their selection process is gone also. Those who are selected, their selection process have gone also. Therefore, all selection process has gone. What the Supreme Court has done? All appointments are set aside. First order. I'm coming later. All appointments are set aside. Whether tainted would remain or untainted, all appointments are set aside. What is the consequence? Nobody in the employment from the selection. Selection process is illegal. Whether unqualified or qualified. Their cases are not scrutinized, their cases have been scrutinized. Selection process itself is set aside as tainted. Selection process has been set aside as faulty. No right to them, no right to others. On the date of the Milord, first date of the judgment, that is that is the page. 3rd April, Supreme Court judgment. Let me read the judgment. That will give. Milord, kindly see the 3rd April judgment. Got the page? Kindly come to paragraph first, 75. Milord, it has been set aside, etc. It has been shown to you a lot, so I don't need to require to show. All have been set aside. Now, your lordships, kindly come to first paragraph 70. আরে ভাই তুমি দাঁড়াও না ভাই, তোদের এক দোষ হয়েছে, ওখানে হচ্ছে শামিম আর এখানে হচ্ছে তুই।
Yes, yes, Mr. Bandyopadhyay.
Kindly come to Milord, page first, 46.
Paragraph 46.
Yes. For candidates not specifically found to be tainted, the entire selection process has been rightly declared null and void due to the egregious violation and illegalities which violates Article 14 and 16 of the Constitution. As such, the appointment of these candidates are cancelled, all cancelled. Selection process is gone. However, candidates who are already employed need not be asked to refund or restitute any payments made to them. However, their services will be terminated. Furthermore, no candidates can be appointed once the examination process and results have been declared void. This is the order. No candidates can be appointed on the basis of that selection. Whether it's unsuccessful, whether tainted, whether untainted, no one can be appointed from that selection process. Not future selection process. Not future selection process. From that selection process.
How you are submitting this? Come to paragraph.
I just give me time. Give me time.
No, because we have to consider it in the light of the order.
I am coming, sir. I am coming. Just give me time, sir. Kindly. Give me time.
We cannot attribute our own interpretation.
No. I am saying, I have my submission.
Yes, yes.
I have my interpretation. Your lordship may accept or may not
The
accept.
court can ask Mr. Bandyopadhyay
Yes,
again
yes.
for SSC that if this submission is found to be in teeth with the order of the Supreme Court.
Absolutely. I am coming. I am making first this judgment's first interpretation. I am saying on that date, I have started with the submission on that date of the judgment has been delivered. Therefore, on that date, everybody should go.
Yes.
And that I am submitting. Possibly I was not clear to your lordships. On that date, now kindly come 47, type to 47 paragraph. Come to 47. Some of the appointed candidates who do not fall within the category of the tainted candidates, kindly see, may have previously worked in different departments of the state government or with autonomous bodies, etc.
That is not relevant.
In such case, all their appointments are cancelled. See, cancelled. But the candidates will have the right to apply to the previous department or autonomous body online service because their continuity in service. Paragraph 47 is specifically for
Some of the appointed candidates who do not fall within the category of tainted.
correct. Those who are working in other department, they will go there and
Repatriation was allowed,
and their and
even necessary by creating
supernumerary and their continuity service has not been disturbed.
interfered with, right?
Their
But that is confined to tainted candidates.
they are untainted. I am saying that is an
Yes.
untainted. This benefit has been given by the Supreme Court. Then kindly come to Miller, paragraph 49. The disabled candidates mentioned in the previous paragraph will be allowed to participate in the fresh selection process if required with age relaxation and other concession. Similarly, other candidates who are not specifically tainted will also be eligible to participate with appropriate age relaxation. Kindly read this line. Only for the untainted candidates there would be age relaxation. But untainted candidates will not be appointed. That's not there. Tainted. So for the untainted candidates, age relaxation will be there. Age relaxation will not be for any other candidates excepting the untainted candidates. This sentence doesn't mean that tainted candidates cannot make application without any age relaxation, or this had not been made for the candidates which application can be made, even the who are unsuccessful, where selection process has been set aside. Kindly read this.
Similarly, other candidates who are not specifically
In
tainted,
our similarly, other candidates
who are
who are
not
not
specifically tainted
specifically
will
tainted
also be
eligible
to
participate with appropriate age relaxation.
Yes.
Participate.
Excluding tainted candidates.
No. No, my lord. No.
Yes.
But this is our.
That cannot be a clarification.
My lord, that is.
That clarification I didn't expect from Mr. Bandyopadhyay.
No. This is my
Yes.
clarification.
Yes.
This is clarification.
Yes, Mr. Bandyopadhyay. I am eager to get an explanation from you.
No.
Which is
My
found to
lord,
be
your
relevant.
lordships may not accept, but don't be annoyed.
No, I am not annoyed.
Don't
I
be
am
annoyed.
Also expressing my mind
No.
so that you can respond.
Yes, all right, but not with annoyance.
No, not at all.
And not at
But
that.
I am also seeing your annoyance not being permitted to make an argument within time. From the
Not
morning.
being permitted to do.
Yes, you are saying that from 12:30 I have other matters. Allow others to.
Why you are mixing up all these issues? Then you could have taken it. I am stopping it.
Because
If this-
accepting your submission and your request, I fix the matter today.
Correct. I am not saying so, but I expected also item 1 is finished. Item 1 I will argue. But if your lordships will.
All the matters, if separately matters are to
No.
also appreciate the
this is
predicament of
this
this
is.
court, Mr.
My lord, I am not come here to quarrel with
Very
your
well,
lordships.
very well.
I have not come up to
paragraph-
quarrel with you.
No, why should
I am
you
not
should-
come.
You have
I am
come
not.
to quarrel.
No. My lord, I am
49.
I am a
your
very
paragraph-
I am a very small lawyer. Why should I quarrel with a great judge of Calcutta High Court?
That knows everybody that you are a very small lawyer.
Yes.
But
I
a
am
judge
very
is a
small
judge.
lawyer.
That
The great
judge
judge.
can
I
judge
can.
can
That's all
ask
right.
query.
Yeah,
or
of
make
course, I am
to
giving an answer.
Any senior advocate.
My lord, I am giving. I
That
am
is the beauty of our constitution.
that. This is
Now
beauty,
the thing is this, Mr. Bandyopadhyay, paragraph 49, your submission is this.
beauty of our constitution is
Yes.
beauty of our is this. If the judge does not accept the submission of a senior lawyer, then judge would become annoyed. This is not beauty.
No, I am not at all annoyed. This is a way this court generally responds.
Listen.
Yes. And at the same time, court also expects that there is no annoyance from from a senior advocate like Mr. Bandyopadhyay.
Why should I?
Because others
I am not.
are looking at you, they are learning from you.
My lord, I will not argue better.
Yes, yes, please,
My lord,
please,
since your
please,
lordship
please
is
proceed.
making so
Please,
much of-
please
My lord, my
proceed, Mr.
junior.
Bandyopadhyay.
No.
Yes, yes.
No, I will not argue.
Please proceed.
Your lordship is making very caustic
Yes,
remarks.
yes, yes, Mr.
Never
Bandyopadhyay.
anybody has made such a caustic
Yes,
remark.
yes, Mr.
No, my lord, I will not argue.
Court
You are a great judge. I will not.
court is eager to hear it.
No, go. You are so. I
Yes,
don't know. Days are changed.
Yes.
That much I can say. Days are changed.
So therefore,
My lord, kindly see.
yes.
My argument is this will also eligible to participate with appropriate age relaxation.
Therefore, your argument is this in a short campus with regard to paragraph 49 is this: those who are tainted, they will not get age relaxation. Those who are not tainted, those who are untainted, they will get the benefit of age
relaxation.
That is your.
That is my argument. That is my argument. And whole rule is based on this. It's an open category. Open category. Now, as it would above these candidates to
Just
take
a minute.
Now, if you restrict it,
yes,
my lord, kindly see, if your lordship restrict it, just for another view I am giving, if your lordship, then only untainted candidates can apply. Neither tainted, not the unsuccessful candidates.
couldn't follow. Yes, please repeat it again.
Let's assume that your lordships, if your lordship says only untainted candidates will apply, then in that case, my submission, interpretation has to be given. Neither the tainted candidates can apply, nor unsuccessful candidates can apply, though otherwise eligible. Kindly appreciate this. That is the reason I have started with this. See, the inquiry was only for the panel candidate. Inquiry was not there for the unsuccessful candidates. We do not know who are tainted or who are untainted amongst them.
But is it required to enter into the this issue after the order passed by the Supreme Court, specifically prohibiting tainted candidates to participate?
I am submitting. Here is no prohibition of any other person. No person is prohibited to make an application. This is my submission.
Now, your submission is that untainted as well as unsuccessful in 2016 selection process will not be permitted.
No.
If that is accepted.
If this interpretation is accepted, that only the untainted candidates would be given the chance with age relaxation, then tainted and unsuccessful candidates are also barred.
Why unsuccessful candidates?
Why not?
Clubbed with?
Why not?
With tainted?
Why not? Did we make any inquiry whether they were tainted or untainted? Inquiry was tainted or untainted. They were unsuccessful. Nobody. Kindly see, my lord. Just excuse me. At any point of time, unsuccessful candidates' fate was not discussed because they are not entitled to. If an interpretation is made, I am submitting, my lord. I am submitting that this with appropriate age relaxation means only in the case of untainted appropriate age relaxation. But it is open to all. But it is open to all. But if it is interpreted that only the untainted candidate can make application of that selection process, then accepting untainted, neither tainted nor unsuccessful candidates can make an application.
Only simple question I am asking.
My lord, I will try to give answer.
In view of the order passed by the Honorable Supreme Court.
Oh, yes.
Or judgment of the Supreme Court dated 3rd April 2025.
Yes.
Read with the order passed on an application dated 17th April 2025. whether tainted candidates should be permitted to participate in the selection process.
This is your question.
Yes.
I am giving you answer. Come. This is the only question, nothing more than that. Now, what has happened? All termination. Effect of 3rd July order is a termination. 3rd July, no?
Yes,
3rd April, sorry.
3rd April.
3rd April, all termination. Tainted, untainted, all termination. Now, from April, there are vacancies. This untainted were not going on in the employment. Then who made an application? Board made an application. Not the state, not the SSC. What they have said, kindly allow us to conclude to make the interview complete. Until that, kindly allow us to continue with this. For which classes? They have made an elaborate application. Now, what the Supreme Court said? Kindly come to page 86 first.
Paragraph?
Page 86 is the order. Let me read this.
No, tell me the paragraph because I am
No, kindly from the top.
order dated.
The order dated, that order what your lordship was referring to? 17th April.
17th April. Just. Yes, 17th April.
We are inclined to accept the prayer made in the present application in so far as it relates to assistant teachers for classes 9 and 10, classes 9 and 12, not found to be tainted, subject to the following condition. We are ready to accept. Prayer for what? Prayer for continuation of their service until the selection process is made. That was a prayer by the board. Now, kindly read again. Kindly excuse me. Sorry, my lord.
Yes.
তোমরা এরকম করো কেন বলো তো? We are inclined to accept the prayer made in the present application in so far as it relates to assistant teachers for classes 9 and 10 and class 11 and 12 not found to be tainted subject to the following
So
condition.
that is according to you is this with relation to their continuation
Of service, not for any other
has
reason.
been extended till 31st of December.
Correct.
Yes.
Those who are untainted, let us kindly see group CD they have not given. Group CB also tainted,
To that
untainted.
extent, there is an observation in this.
That's right. Group CB did not. Only for 9 and 10 and 11 and 12 continue with this service. That doesn't mean no, they will continue with this service